Every Tuesday, we do bring in immigration updates. Along with me is my business partner, Emily. Emily, what do you have today to discuss?
Today, we want to talk about H4 EADs and the new rule that requires you to go for biometrics because they don't accept your passport photos anymore. How is that impacting processing times? How to deal with that so that you can avoid a gap in your employment authorization because of the other recent rule that says there's no more automatic EAD extensions, even if you get your I-94 extended. We'll also talk about using premium processing before the I-94 expires to avoid the risk of your status expiring and then getting a denial, why we recommend that, and what you should do to make sure that you don't fall into that situation. We'll also talk about the rule regarding the 180-day rule regarding I-140 approvals, why you need to stay with the employer for at least 180 days after the I-140 is approved, and what happens, what benefits that provides, and what happens if you don't. Lastly, we'll talk about the H1B and the 6-year limit. What are your options if you are getting close to that 6-year limit and your employer is not sponsoring the perm for various reasons?
Emily, H4 EAD, normally it's better to file along with the spouse H1B application, the main applicant's H1B application, because when you file H1B, H4, and EAD together, you will have a higher chances of getting it approved along with the H1B. Now, of course, we have seen up to 60 to 70% of the H1B and H4s and EADs used to get approved. But now there is a different theory that the EAD person, they don't trust the pictures that we sent it. Now, these people have to go for biometrics until get the picture done. So there is a 2-week delay in getting the EAD approval. And now, sometimes that becomes a problem because if my EAD expires, if the H4 EAD expires, that becomes a problem. But if they file the H1, H4, and EAD very early, they get the H4 and EAD approval. Normally they have an EAD. Let's say they're filing in April, and they have until September the H4 and EAD. If there's a gap of 2 weeks or 3 weeks when the EAD is there, that's fine because the EAD they have until September. But there are some situations where people are moving from F1 to H4 EAD. There are people moving from H1B to H4 EAD. What in that situation? How are you managing it? So if the person is going from F1 STEM OPT or probably an H1B, and now they're moving into H4 EAD, what is the best thing to do it for them, though? Because for them, the H4 is approved and there is a 2-week or, about between 14 to 20 days gap.
Yeah, I mean, the best thing to do is to file early. Obviously, if you're in that F1 STEM OPT situation, when your OPT is expiring, you want to have the new H4 and H4 EAD approved by the time that the OPT expires. So you're going to have to file 6 months early. And even with that, you may end up not getting either of the approvals in time before your STEM OPT expires, and have to stop working and then get back to work only when both the H4 and the H4 EAD are getting approved. There's not a lot you can do except that if your spouse's employer is willing to file an H1B amendment, even if there's not one technically necessary, that could allow you to file an H1, H4 EAD in premium processing altogether and get the approvals much more quickly that way. Otherwise, if you can time it with an H1B extension or an H1B transfer so that they can all be filed together, that's the other option. Last option would be litigation. After the EAD has been pending for 3 months, we are still having to do that again. We saw that quite a bit during the previous Trump administration, and we're back to doing it again and seeing that be effective.
So essentially, if the person is moving from OPT or H1B to H4, there will be a gap, is it right, Emily?
Yeah, unless they're able to file with their spouse for some reason, either by filing an amendment or filing
what if even if they are filing with the spouse right now, they are getting the H4 approval first and the EAD is taking time?
Not necessarily. So, for example, today I received, so we had a H4 extension filed with an H4 and H4 EAD. The H1 extension got approved after the biometrics for the EAD. A couple weeks later, we got both approvals at the same time for the H4 and H4 EAD. Of course, there's no guarantee that always is going to happen, but there isn't always a gap between H4 approval and EAD approval. It's more still the gap between H1 approval and H4 approval.
One other thing people can do is that, let's say if your biometrics has been issued 15 days to 20 days from now, what you could do is that you can always go early biometrics, though. I've had a lot of people who are going for early biometrics, and they are entertaining the early biometrics, though. Now, I've seen last year, though, that they were not entertaining the early biometrics. That means that even if your biometrics date is, let's say, for example, May 6th, people can walk in and on April 28th and then still get their biometrics done. So that's one thing that you can do to avoid delay in the H4 EAD. Emily, in situations where a person is applying H4 and EAD, let's say, for example, they are an H1B, okay? I want to discuss about margarita switch. What is this margarita switch? I just want to explain people is that if people have an H4 approval and they have the H1B approval and they have the job with that particular company, you can switch to H1 to H4 just by going to Mexico and flying back. And you can switch from H4 to H1 by just flying back to Mexico and coming back. People ask the first question to be, I don't have the visa stamping of either H4B, H4 or H1B. That is considered to be as automatic revalidation. Only if you go to Mexico or Canada, and you're coming within 30 days and you don't have any visa appointment, you can come back with the I-797A approval. Since you already have the H1B approval and or the H4 approval, you can always come back into United States using the automatic revalidation approval. Especially this becomes very important because when people file from H1B to H4 plus EAD, and they don't want to have any gap period though. Let's say the H4 is approved and sometimes the EAD doesn't get approved at the same time. Most of the time, 90% of the time it gets approved together if you file it together, but there are 10% of the time it doesn't get approved together. At that point of time, you can fly to Mexico. You can come back since your H4 is approved and your EAD is no longer approved. You want to continue employment. You fly to Mexico. When you fly back, you show them the H1B approval. Since you still are working with the company, the job is still there for the company. You can still fly back on the H1B approval. Now, I have seen many situations, even though people come on H1B, the EAD gets approved. What do you do at that point of time? You want to switch back to H4. Because you want to work on H4 EAD, which has a lot more flexibility. You can do one thing. If the EAD is approved, you have an H4 approval with you, you fly to Mexico again. You fly back on Mexico. You show them the H4 approval. Now, you are still married. Your spouse is still working. So they will only ask question about your marriage, which you know how to answer and all those things. I don't have to explain anything what to do. So they will not ask any other questions. That's all. You just come back into United States on H4. We call that as margarita switch because margaritas are good in Mexico. Believe me on that, okay? Now, you can go to Mexico, have a margarita. Now, if you don't have a visa stamped in the passport, you need a Mexican visa. Normally, it takes only 3 to 4 days to get a Mexican visa. Now, if you already have a Canadian visa, you can always go to Toronto and fly back. You can do that too. So this is what we call as margarita switch. It's also, you can look into the CPP's website. What I'm speaking about is called automatic revalidation. And trust me on this, guys, we send a lot of people on automatic revalidation. People ask me, no, I don't have the visa stamping. How can I come back into the United States? There is an automatic visa revalidation. That means that this is only applicable when you go to Canada and Mexico, not to any other country, guys. So you can use it automatically. Anything else, Emily, on this topic?
No, let's talk about premium processing and, before the I-94 expires. Let's say that you are due for your renewal, your extension, and it's expiring in 30 days. You're getting ready to file, and you're, planning to file in regular processing because you get automatic employment authorization. Your status continues for up to 240 days based on the pending extension. Why would I want to file that in premium processing?
Couple of reasons. First of all, I want everybody to file the H1B. You have up to 180 days you can file it. You don't have to wait for 30 days. I always recommend people filing 180 days before. If you're filing within 3 months, though, within the span of 3 months, let's say, for example, if your H1B is expiring in July, definitely, and you're filing in April right now, definitely go for the premium processing, though. There are several advantages for you for going, and don't try to use the 240-day rule. What is the 240-day rule? Is if you're filing for H1B extension, company A filed H1B extension, even though your I-94 expires, you can continue working for 240 days. And people will tell you, why do you have to waste premium processing when you can continue working for 240-day rule? Several reasons. One reason is that what if the H1B gets denied? I mean, last Trump era, though, we have had so many H1B getting denied, then we have to send them back to India, file the H1B, and then they're back. That option is no longer there. Because if your I-94 expires, if the H1B gets denied, if your company or any company wants to file H1B, now they have to pay $100,000 fees. I already have an I-140 approval. I'm already being counted in the H1B. Why do you have to pay the $100,000, please? Yes. If we are going for consular processing, you still, even though you are not going through the lottery, even though you have an I-140 approval, you still have to pay $100,000. The company has to pay $100,000 fees. So that option is practically closed right now. The other thing, let's say, for example, your H1B is expiring in July, and you don't apply in premium processing. And right now you're in August, and you lose the job. And that's happening very frequently nowadays. You lose the job. Now, if you lose the job, the company has to withdraw the H1B. There's no option. What are you going to do about that? Your I-94 expired. At that point of time, you cannot find a different company to file a H1B because your I-94 expired. You can't file a H4 because your I-94 expired. You can't file an F1 because your I-94 expired. You can't file a B2 because your I-94 expired. This is not good at all for you. In this case, then you have to leave the country. Once you leave the country, that's it. You can't come back, because if you want to come back in H1B, guess what? Uncle Sam wants $100,000 from your company. And I don't think so many of the companies are willing to pay $100,000 for you. Emily, can you say why they need to do any more reasons?
I think, yes. The other issue is when you get a denial after your I-94 expires, not only does it put you out of status, but you start accruing unlawful presence from the very next day of the decision. And that means that you are at a very high risk for USCIS issuing a notice to appear, an NTA, in removal proceedings, because now under the Trump administration, they have the authority to issue NTAs to anyone who's unlawfully present at the time they receive a negative decision or a denial notice. And we are definitely seeing that. And so you basically don't have any options. You can't file a late change of status to anything else. If you were to stay and try to make some sort of nunc-pro-tunc argument about the late filing, while it's pending, you could get an NTA, and then you end up in removal proceedings. So your only option at that point is to leave. And then, as Rahul said, to get back, the only way to get back on an H1B right now is for the $100,000 fee to be paid.
If my extension gets denied and it's my H1B is valid until July 2026, and I file the H1B extension, if the H1B gets denied because either specialty, occupation, or for some other reason, can the same company file another H1B for me, Emily?
If the I-94 has not expired, yes. So that denial does not impact your already granted H1B and your approval that's valid until July in this scenario. So as long as you get that decision before July, the company can turn around and refile. Maybe there's something that they can provide additional documents. Maybe they can change the SOC code or the wage level so that they're overcoming whatever those grounds of denial were, you have the opportunity to do that, or you could file a transfer even in that situation. So that definitely a lot more options when a denial happens before your I-94 expired compared to after.
So if ever you want to use a 240-day rule, though, you can always use in the secondary filing. So it's definitely very advantageous right now for you to get the 3-year extension right now. And here's another thing, though. You get a 3-year extension, guys. The next extension, the Trump is not going to be the president. That's a good news for you. That means that you're out of major trouble. So just try to get it now. While the I-94 has not expired, though, it is you who control the things. Once the I-94 expires, it's either your employer, because if you lose the job, that's it, you're out. The company is going to withdraw. No, I will request my company not to withdraw. They are under obligation to withdraw the H1B. So that's a big no for you to get the extra. If you lose the job, you lose the 60-day grace period at that point of time. So that's another thing. Also, when your I-94 expires, you're supposed I-94 also expires. You're also, if they are dependent on you, that's also another reason why you need to get the decision before the I-94 expires.
All right, next topic. Once you have your I-140 approved, what is this 180-day rule?
If the I-140 has been approved, and if the company does not withdraw the I-140 for a period of 180 days, practically you can use that I-140 perpetually forever. There are some limitations, but with some exceptions, but you can use it forever for filing the H1B extension with the same company, for filing the H1B with a different company. Let's say you move on from company A to company B, you can you can file the H1B from company B. You can extend the H1B with company B. You can move from company B to company C using the company A's I-140 approval, company C to company D with the company A's I-140 approval. You can use your spouse, even though you got the I-140 approval with company A and you are right now working with company C, your spouse, if the person is on H4, can apply for the H4 EAD. The magic rule is that the I-140 should not be withdrawn within 180 days after it's been approved. A lot of people ask me this question, Emily, that I'm working with this company and I'm going to leave after the I-140 is approved. The company is not going to withdraw the I-140. So do I have to stick with the company for 180 days, or the company should not withdraw the I-140 for me to use this I-140 perpetually?
The withdrawal is the important part there. So it doesn't necessarily mean you have to stay with the company, as long as they don't withdraw within 180 days. If you leave on day 1 and they withdraw on day 181, that's totally fine. But if you leave and they withdraw on day 179 because you left, that is where you lose all of those benefits of being able to use that I-140 for continued H1B extensions, and your spouse can no longer use that I-140 for H4 EADs.
I'm working on H1B, and right now, because of some layoffs, my company is telling that they cannot file the POM labor certification. And I'm going to be coming near to 6 years now. Everybody knows that unless the POM has been filed and has been pending for more than 1 year, in which case I can get 1-year extensions, or when the I-140 is approved, I get the 3-year extensions. My life on H1B ends on 6 years. What are my options if my company is not going to file the POM application?
Number one, you could look into the self-filing options that allow you to directly file an I-140 petition without the need of a company and without the need of the PERM process. That includes National Interest Waiver, EB2 NIW, or EB1A Extraordinary Ability. Definitely the NIW approval rate has gone down quite a bit during the Trump administration, so that may not be as readily of an option as it was in the past. If your spouse is also on H1B, you should consider changing status to H4 because that time stops the clock of the 6-year limit. You can still be sponsored for labor certification or I-140, even if you're on H4. You don't need to be only on H1B for that. You could look at change of status to other categories, maybe F1 if you want to do some additional study. You could also consider recapturing. Of course, this requires you to travel, which we don't generally recommend, and you need to have a valid visa stamp. But any time you spend outside the US, you can recapture that to extend out your H1B 6-year limit to potentially buy yourself additional time to be able to get a perm and or I-140 filed on your behalf. And you can look at companies outside that you are not currently working for. It is possible for an employer to sponsor your labor certification if you're not employed by that company at the time of filing. So that can provide you with a way to both lock in your priority date, get the perm and I-140 approved, as well as continue extending beyond the H1B 6-year limit.
Anything else, Emily, before we go to the questions?
Most important thing is start thinking about that early. Don't wait until you're in year 6 to start thinking about it, especially for the perm process. Nowadays, you really should be getting that filed around the 4-year mark because it's taking so long to get through that process. The longer you wait, the fewer options that you have.
Yokesh has an interesting question. His wife has the H1B, got the H1B lottery, but she has an H4 EAD until 2029. What is a better option for her? Now, it's always good to have both the people, both the spouses, counted towards the H1B lottery, because if you have your wife on H4 EAD, later on you lose the job. What happens to you? Then you will have to pack the bags or leave or convert into F1 visa. You'll be in greater trouble because at that point of time, if you want your wife to be converted into H1B, she has to go to the lottery. So for her to be counted toward the lottery, what I want you to do is get the H1B approval. Let her stay for about 2 weeks at least on H1B. Then what you could do is you can always switch her back to H4 EAD. If I file the H4 EAD, you told me that there will be a gap of 2 to 3 weeks when the H4 gets approved and the EAD doesn't get approval. There is a solution for it. It's taking about almost, for some people, anywhere between 6 months to 14 months to get the H4 plus EAD. There is a solution for it. We call it as margarita switch. That's it. All you do is that instead of spending a lot of money on lawyers to file the H4 plus EAD, okay, and then it takes 14 months for the USCIS unnecessarily, all you need to do is that your wife goes to the sandy beaches of Mexico, spends their time, and she flies back. She has a margarita, and then she flies back. When she flies back, she will show them the H4 approval. That's it. That is what we call it as margarita switch. Yogesh, this will be the best solution because once you do the margarita switch, now she will be on H4. Let's say that this is in October 20th, she's back on H4 visa. In 2026, what if in 2028 you lose the job? And let's say she has a job and that company can file a H1B at that point of time, saying that she was in H1B for 2 weeks period, and H1B was approved with the I-94, and then you can move to H4 if you needed to. So it's always better to use the margarita switch in this situation, have your wife get the H1B approval.
Sai says, my I-140 was filed for future employment with company A. I've not joined the company yet. If the date becomes current, can company A file the 485 and what are the conditions? Yeah, the whole process of the employment-based green card system is based on the future job you will take when you get your green card. It does not need to be the job or the company that you are with today on whatever your non-immigrant status is. So as long as the company still has the job offer that they made to you, mentioned on your labor certification and on your I-140, and they intend to offer that job to you, and you intend to work for that company in that job when you get your green card, you can absolutely file the 485. You file it personally. It's not something the company files, but you do need to get the company to provide you with the Supplement J form. That is the document that confirms that they're still offering you that job and they want you to join when you get your green card.
Question from Parishta Kulkarni. USCIS is considering final action dates for the month of May. I filed my adjustment of status in April. What's going to happen with my application because my dates are not current in May? It's perfectly all right, not a problem. They will consider your application because it's been received by USCIS in the month of April. They will adjudicate your EAD and advance parole. They won't give you the green card, but they will adjudicate the EAD. What does that mean? No green card means they won't grant you the green card, but the interim benefits of EAD and advance parole, they will adjudicate the application.
Harsha says, I have a birth certificate which does not have my name and my mother's name on it, but has only my father's name and my date of birth. I have affidavits from my mother and father. Can I use them? Well, you can still use the birth certificate. It is your birth certificate, so that qualifies and you can file. USCIS might ask for additional secondary evidence. At that point, if they do, then you can provide the affidavits as well as additional corroborating evidence to support those affidavits. That's typically going to be school records, hospital records, church records, or something like that, that has your name, your date of birth, parents' names, and that sort of thing. But you can absolutely still file in that situation.
Sarvanan has a similar kind of question. His name is missing. The first name is missing. Is that going to be okay? Can I get an affidavit? Will there be enough RFE? Most probably there shouldn't be any RFE, but always get an affidavits. I normally won't submit Aadhaar card, PAN card, ration card, election card, school certificates, or hospital records. I may not submit all these things if I have, but I will keep them ready just in case if there is an RFE though. As long as the date is correct in there, we have had no issues in getting the in getting the green card approval based on the birth certificate. If the parent's name is first name is missing, last name is missing, your first name is missing, your last name is missing, it's fine. As long as that your date of birth is there, then if there are other small clerical things, it's not a big issue at all.
Blue says, my 485 got approved 3 weeks ago, but my spouse's case is still pending. Is there anything that can be done? We saw this a lot previously. It seems to be happening again. And your best option is usually going to be litigation, as long as your spouse's 485 has been pending for a year. Not a year after yours is approved, but from the very beginning, from the day it was filed. If it's been a year, litigation is going to be your best bet there to get your spouse's 485 approved. Otherwise, it's not considered outside normal processing time. They don't care that yours was approved. Maybe yours was approved fast. That doesn't mean that they have to approve hers fast. So there's not really any other option for them to speed up her process.
Can I apply H4 EAD along with the I-140? No, because the address where the H4 EAD goes is different than that of the I-140 approval. You have to wait until the I-140 is approved, and then you can apply for the EAD. The question that comes is that, can I apply H4 and EAD 1 year before? Let's say your spouse H1B has been extended. I have never seen a problem when the main applicant's H1B has already been extended and people have filed 2.5 years in advance. I've never seen any problem in getting the H4 and EAD as of now.
Sharon says, I have a valid visa stamping, and I'm going to be applying for my H1B extension in July. Can I travel internationally while the H1B extension is in progress? Or is it possible to apply for the H1B extension while I'm outside the country? Neither of these are good options. Technically, yes, you could travel while it's pending. Why don't we recommend it? Number one, we're not recommending international travel, even if you have a visa stamp. But number two, what do you do when your extension is pending and you travel and then you lose the job while you're outside the US? Your extension is going to be withdrawn. You can't come back. You have a valid visa stamp. Great. Another company can file an H1B for you, only if they're willing to pay $100,000 because you are outside the US at the time of filing. That is a way too big of a risk to take. And you definitely cannot file an H1B extension while you're outside the US because, again, that's the $100,000 fee requirement. So no, not a great idea.
Question from Vittel has this question that does a margarita switch work from L2S to H1B, change of status this year? Absolutely, it works. So if the L2S person has moved on to H1B and then later on they want to move to L2S, absolutely, all they need to is that in two-way ticket to go into Cancun. It's a very nice place, guys. Cancun, sandy beaches, nice place to go and enjoy and have a nice thing. And don't forget to have a margarita. Because why? Because we call it as margarita switch.
Ronick says, today on X, Stephen Brown and another attorney, Charles Cook, said all green card cases, final adjudication are on hold due to the shooting in DC at the White House Correspondents' Dinner. How true is this? My 485 is pending. I mean, attorneys did report that that's what their clients were told at the end of an interview. I don't know if it was a one-off situation or multiple people heard this. It's all kind of rumors and through the grapevine at this point. There was also a post on X that said that USCIS had just implemented a new policy for review of applications before final approval, and they were putting things on hold until they implement that. I don't know if that could be what the issue is, and that did not seem to be based on anything to do with the shooting. So it's anybody's guess right now how valid of a statement that is. Sometimes officers say things that maybe they misunderstood or misheard. So no truth to that we know of at this point.
What's the processing time for I-140, normal processing versus premium processing? Processing time for I-140 is anywhere between 2 months to about 8 months. Of course, you know the premium processing is 3 weeks right now. Now, if you're filing a I-140 in EB2 and EB3, based on the labor certification though, we strongly recommend filing a premium processing though. But if you're filing national interest waiver, EB1C or EB1A or EB1B, we do not recommend premium processing because there is a high rate of RFP if it's a premium processing. It's a lot of advantage for you to file an I-140 in premium processing, especially if it's a POM labor certification. The reason is that what if you lose the job? And what if you leave the job within a short period of time after the I-140 is approved? So it's always good to get the I-140 approval in premium processing. A lot of advantage. It's very similar to if this is your first I-140 now. If this is a second I-140, that means you already get an I-140 from company A and now you're getting from company B. Yeah, there is no hurry for it though. But if it's a first I-140, we strongly suggest you get the I-140 in premium processing.
Current wait for EAD and AP after filing the 485 to get it approved. It's very inconsistent. Sometimes we're seeing them as fast as 3 months. Sometimes they're taking more like 8 or 9 months, and there's no rhyme or reason to it.
I'm in India since August 2022. My prior date is 2019. Can I file EB1C? My current role is managerial position only. If you're eligible for EB1C, the company that wants to employ you in United States, you must be in India, so you must work for the same branch office in India. So the company here can file EB1C and they can even do consular processing. That means that you can get a green card in India. They can file a consular processing so that you can get it in. They can recapture the priority date of 2019, which is current for EB1 category.
Johnny says, is there a requirement to stay 180 days after getting the 485 EAD? No, the 180-day rule when it comes to a 485 is 180 days from the day the 485 was filed. From that point, that's when AC 21 kicks in, the American Competitiveness in the 21st Century Act, which created portability. It allows someone who has a pending 485 to move to a different company without having to start the process over again. And you qualify for that 180 days from the date of filing the 485, has nothing to do with the EAD.
I submitted my medicals in March. I get RFE now to submit medicals. Can I use the same medicals submitted in March? I'm assuming that you have another set of originals with you right now. Then you can. But if you're just telling that you have a copy, you're going to submit it, that doesn't work. The medicals have to be original, they have to be sealed. So if you have them, yeah, definitely you can.
Kashish says, is it the $100,000 fee expiring in September 2026? Yes, currently that is correct. It ends September 21st, 2026. However, they have the opportunity to extend it, and they're supposed to be getting some sort of report on that, which will help them decide whether they're going to extend it or not. There is nothing in out there that would suggest that they won't extend it. I just don't see that happening. I think we're going to have this till Trump's out of office or until it gets shot down by a lawsuit.
Any update on the LCA wage levels, Emily? We are expecting it to become law by end of this year. Is that right, Emily?
It's possible that it might. I mean, it has to be published first, the final rule. But I was expecting it to take effect from July 1st, which is when the new prevailing wages come out every year. I don't know the fact that we have a new DOL secretary. Maybe that could delay it a little bit. But yeah, I do expect that to be happening this year.
Can parents travel back to India after filing I-131 re-entry permit? Filing date is March 20, 2026. Case is under processing and no biometrics appointment scheduled yet. They can travel to India, but I want them to come for biometrics for sure. And I want them to come within 180 days. That's one thing, though. Just because you filed the re-entry permit doesn't allow you to stay outside the country for a long period of time. So you still need to, they still need to come within 180 days. Once the re-entry permit has been approved, normally re-entry permit is approved for a period of 2 years, then you can spend a long time outside within that period of time. But definitely they need to come within 180 days.
Naveen says, my I-94 on the CBP site is expiring August 2026. I recently renewed my H1B and premium processing and got extensions till August 2029. Do I need to get the I-94 updated on the CBP site? No, you don't. So the only time the one gets updated on the CBP website is when you travel. Once you're in the US and you file an extension, that extension comes with a new I-94 attached to it down in the bottom corner. That takes the place of the one on the CBP website until you travel again. And at that point, you need to log onto the website and verify that they gave you the correct end date on the new one. But if you don't travel, you use the one that's on your I-797 approval.
What are the parameters to consider for writ of mandamus for the H4 EAD delay? Is job loss, financial hardship, along with loss of health insurance? Yeah, all those things, any of those things could be the reason for filing a writ of mandamus. Now, the same thing, we are not encouraging a lot of people whose final action date is current to join the court litigation that Stephen Brown from our office does it every week. So we have a free Zoom call for those people who wants to file the litigation for the H4 EAD and also for the adjustment of status delay. If it's been more than 1 year that the 485 has been pending and your final action date is current, then we recommend that you go and sue the government though. Now, your final action date doesn't have to be current for a period of 1 year. It just needs to be current right now. That's one thing. A lot of people ask us the question, Emily, hey, going against the government, the police is going to come and arrest me. The military is going to take me and shoot me down. They will take me in the airplane and shoot me down. Does it happen?
Thankfully, no. None of that is allowed in the United States and would certainly be illegal. But no, they do not retaliate. They're not allowed to do that. They don't retaliate against you and deny your case. They don't make it harder for new cases to be approved. They don't impact your visa stamping. It is your right as someone who is interacting with a federal government agency to sue, and they do not retaliate.
Imagine this, guys. Look, Trump has said about the tariffs. And then guess what happened? People went to the court and Supreme Court said, no, tariffs is illegal by Trump administration. Not only that, is now paying back all the tariffs, approximately $400 billion he has to pay back that money. No retaliation. And if there is a retaliation, it'll be first on the lawyers, guys. That's us. It'll be retaliation on us. The other thing is that, birthright citizenship. You know what the lawyers did? They went to the court. Now, when we see that it's illegal, we go to the court. And when we are speaking about the AOS delay, when we are speaking of the EAD delay, do we have to go with the online timing of the USCIS? No, because when they issued the 765 form, especially for the H4 EAD, they said it takes just 10-15 minutes to adjudicate the application. They're going to take 3 months to adjudicate the application. And it's been long period of time that they're taking for you to adjudicate the application. So it's right for you to go for the writ of mandamus. Same thing in adjustment of status. They said they would adjudicate the application in 6 months. They're not doing it. And the filing fees, we didn't fix the final fees. They fixed the final filing fees. They said that money is good enough for them to adjudicate the application the proper timing. So that's a basis for us to sue in the writ of mandamus, guys.
Aziz says, had multiple case status updates today, 4/28. RFE response received, premium processing clock started, premium processing clock stopped, and now the current status is premium clock stopped. Is it normal? Do we need to worry about something else? It is normal. 90% of the time when I see that after I've submitted an RFE response, the next status that we see is an approval. A lot of times it was happening in the same day, but sometimes it can happen up to a week later. I have no idea why they say the clock stopped and that we've mailed you something, because it's just not true. So most likely it means the case is headed towards approval in the cases I deal with that.
Nomad is telling that, hey, PERM labor certification is taking 2 years now. What is it going to come down in future? Well, this administration, definitely with the new labor secretary, we don't know if it's going to change anything on that. But I want everybody to aware that it is taking 2 years to get the PERM approval. Now, there is a process for prevailing wage, and there is a time process for doing the recruitment. We have to do all that. And then afterwards, we have to file a PERM application. Once the PERM has been filed, it's taking almost 17, 18 months to get it approved right now. But before the filing the PERM, it takes a lot of time. It's not like an LCA for H1B, where we can get that done in 1 week period of time and file the H1B. That doesn't happen in a PERM. It takes time. So everybody who is an H1B need to be aware that if you get an occasion, though, I want you to file the PERM labor certification in the first year of H1B, not in the second year of H1B. Remember this, because otherwise life ends for you after 6 years of H1B. You know that you can't extend the H1B. We don't have to tell you the rule that H1B is only limited to 6 years unless you have a PERM filed and I-140 approved under limited circumstances. If the PERM is pending for more than 1 year, you can extend the H1B. So it's better that you do that as soon as possible, guys.
Prashita says, I heard USCIS is only considering the final action date chart for May 2026 and not the filing date chart. The filing date was current and I filed my employment-based 485 and EB2 in April. Will USCIS consider it? So once you filed your 485, if it was whatever chart it was under, it was current in the month you filed it. Whether they use final date or filing date going forward does not make any difference to your pending application. The final action date is the one that has to be current for them to approve your application. The only purpose of the filing date is for sometimes to allow people to file early before the final action date actually becomes current, and they turn it on and off in a given month depending on demand and how many 485s are being filed. So that has no impact on an already filed 485, except that regardless of which chart they're using in a given month, they can only approve your 485 when your final action date is current.
My husband is an H4 EAD. I'm an H1B with I-140. Will I-140 still be active if I convert from H1B to H4? And future, can I apply for 485 when the dates are current? Now, if you're an H4 and if your company that has an I-140 is cooperative, Can you file the adjustment of status while on H4 as a primary applicant? The answer is clearly yes, you can. Absolutely not a problem. You don't have to be an H1B to be the primary applicant for the adjustment of status. You can be an H4 and then be the primary for the adjustment of status if your prior date is current.
Chandra says, my perm is recently approved. Can I apply for the H4 EAD along with my I-140? I'm assuming you mean the H4 EAD for your spouse, but the answer is no. You need to file the I-140, and then once that's approved, your spouse can file for the H4 EAD with the I-140 approval notice.
Second. I'm on day one CPT. My H1B got picked. If I go for premium, and if the H1B is approved in July, if I lose the job, what's going to happen at that point of time? This question is coming from Srikanth Gadipati. Let's say, I'm not going to comment on the day one CPT. Let's say you're on STEM OPT or you're on, OPT. If you apply if you get the H1B approval in July and you lose the job in, let's say, August, okay? You are in STEM, you have a work permit until October, so you can continue working, but that work permit is independent of H1B because you are on STEM OPT or some other work permit with a student visa. You can continue working based on that until October. From October, you can't work because company A filed H1B, you're working for company B. So company B should file a H1B though. So if they file the H1B on October 1st, you're good. I mean, you can continue working for the same company though. So the company B, what I meant to say is that. So if you lose the job in July, you join the company B and company B will file a H1B with October start date. You are all good. That's a good thing. And that's another scenario why premium processing might be a better option for some people though.
Maddie says, my 797 expiration is June 2027. What is the best time to go for renewal? I mean, ultimately, you want to start that process in November 2026 so that you can file in December 2026, which is 6 months before your I-797 expires.
Conweb has this, Kranti Conweb has this question. My wife's birth certificate is in Hindi. What do I do? How can I file the adjustment of status? Absolutely not a problem. If you know how to translate English to Hindi, you can translate it. And there is something called certificate of translation. You have to do the notarization that you know Hindi, you know English, you translated it, and you can sign under the notary, and you'll be good. Absolutely not a problem. If you don't want to translate, you don't think so the words are easier, there are some translation agencies you can look into, especially the USCIS. They say USCIS approved. There is no USCIS approved, but you can look into there. They normally charge between $30 to $70. And they will give the certificate of translation that is a notarized one. Please obtain that one from them. If they are not giving it, don't get the translation. Translation by itself is not good. You need to get the certificate of translation under notarization. Once that is there, it's completely accepted. Absolutely not a problem. We had no issues with any birth certificate which is in a different language. I've never had any issues as long as its translation is there and certificate of translation is there.
Harry says, my company is filing my perm with a different title versus what's on my H1B. If my H1B extension is filed based on the pending perm, does that impact anything? No, they don't have any relation. They don't need to be for the same job for you to use that perm to extend the H1B beyond the 6-year limit. No issue at all.
Nomad has this question. My employer has been pausing POM labor certification. It's been 3 years because of the layoffs. What do you suggest? Probably change the job to a company which is not doing layoffs. If you can find some company, even though you're working for company A, if you find company B to file a labor certification, that's another option that you need to think. But I want you to take the option right now. Think of this thing. What do you think so in the next 2 years or 1.5 years? your company is going to file a POM labor certification. If you think so that they're not going to file because of the layoffs, then it is time for you to move to a different company. Oh, my job, it's not easy to get a job. Well, there's nothing easier in the world, at least for non-immigrant visa people, guys. So definitely you need to polish your skills so that you are in high demand and you can command the things to file the labor certification. But there's also something called national interest waiver. If your work is very crucial, which is in the national interest of the United States, there are ways to get the national interest waiver. It's called NIW. You can get it evaluated by one of our colleagues called Kareem Jivani in our office, though. But, not everybody will be eligible for it, though. So think of moving to a different company, or if you're eligible. If you're not eligible for it, though, he will evaluate. Tell what are the things that you may do to become eligible for it. Those are the things you may want to consider, though.
Vasu says my H1B extension was approved and valid until July 2027 based on a pending perm. But the perm was later denied. And so the actual H1B max out without the perm was July 2026. Is the current H1B approval notice still valid for working? Yes. So even though you filed for a 7th-year extension based on the pending perm, got the 7th-year extension, and then the perm was denied, your H1B extension beyond the 6th year is still valid until it expires. You need to make sure that you have something in place, whether it's a perm or I-140 approval, in time to file your next H1B extension.
Kashif Ibrahim has this question: the closed loop circuits of Bahama, and the person has traveled in the cruise. His I-94 has been given based on the visa stamping instead of the I-797. Definitely, he is not in a good position. He needs to contact the immigration lawyer. One advice that we are telling everybody is that, guys, just don't go on the cruises. Simple. If it is outside United States, and most of the cruises that originate from USA go outside United States, either to Bahamas, Mexico, or Canada, or Alaska, please don't go on those cruises. Do not go on the cruises unless you get a proper legal advice, unless you have everything there. Because most of the cruises, when you come back to, there's no CBP officer. You just scan your passport and you get entry into it. There's no way to show the H1B approval itself at all. So definitely not a good idea for anybody to go on the cruises.
Krishna says, my daughter's I-94 is expiring May 24th, 2026, since her passport is expiring, but her visa is available till end of 2026. What's the easy way to update the I-94? Well, because you are aware of it before it expires, probably the easiest thing to do is to file an I-539 application to extend her status, and do it based on the May 24th end date rather than the visa end date. Other option could be to travel, but if only your child needs to update the I-94, that might be going a little bit overboard because the rest of the family may not want to or need to travel. So you can simply file with USCIS because you found out about it early. That's the most important thing that people need to be aware of. This passport causing the I-94 to be cut short is so common and so easy to fix if you realize it before it expires. After it expires, it becomes a much bigger issue.
My wife is an H4 stamp, and once my child is 4 months old, my wife wants to travel to India and she wants to get an appointment for stamping. We are just advising people not to. One thing, even if the stamping appointments were been given, there are a lot of times people are postponing those things. And when they're postponing it, they're postponing indefinitely, sometimes by more than 1 year. So definitely not a good idea for a father to live without a child. I mean, my newborn child is 4 months old. I don't want to live here because my son is stuck there in India for a while. I mean, son can't come because the wife can't come, and wife can't come because the passport visa stamping got delayed. So I definitely not advising people at this point of time to travel. Anything else, Emily?
I guess we are out of time for today. Thanks everyone for joining. We'll be back again next week on Tuesday at 5 o'clock Central Time to give you the latest updates and answer your questions live.
Thank you very much for tuning.